Hello, and welcome to the first in our series of product liability web chats. Over the course of the series, in less time than it takes for a tea break, we'll cover topics ranging from recall and collective redress to no-fault redress systems for COVID-19 vaccines and cladding claims. My name is Victoria Curran, and I'm a partner at Brown Jacobson Solicitors. Today, I'm going to take you on a whistle-stop tour of the effect of Brexit on product liability law. So grab your beverage of choice and let's get started. As with most things Brexit related, it's possible to talk for hours about the implications, but luckily for you, I'm just going to touch upon some of the key things you should be aware of when it comes to product liability law. I'm going to cover the UK CA mark, the change in status between manufacturer, importer and distributor, and the impact of Brexit on the Consumer Protection Act 1987. As the majority of the UK's product liability and safety landscape is derived from EU law, the long-term impact of Brexit has the potential to be significant, particularly given there is increased focus on the suitability of the current product liability regime in the context of new technologies, such as artificial intelligence and emerging digital technology. In the short term, however, the changes are relatively minor. By way of a very quick summary, product liability law derives from three sources: contract for the sale of a product, tort, which holds that those involved in the manufacture, importation, and sale of products have a general duty to avoid causing harm to those who might reasonably be affected by their negligence, and finally, legislation. This legislation is derived mainly from the Product Liability Directive 1985 and the General Product Safety Directive 2001, both of which are EU laws. Those directives were implemented into the law of England and Wales by the Consumer Protection Act 1987 and the General Product Safety Regulations 2005. Both pieces of legislation currently remain in force despite Brexit, but with some practical amendments. So dealing first with the UK Conformity Assessed Mark, or the UK CA mark. This replaces the EU's CE mark for products being placed on the market in England, Wales and Scotland. In essence, the UK CA mark is required for those goods which would have required a CE mark if placed on the EU market. Products already manufactured and bearing the CE mark prior to the 1st of January 2021 may still lawfully be placed on the market in Great Britain until the 1st of January 2022. Newly designed products yet to be placed on the market will, however, require the UK CA mark to be placed on the market. If a product is to be placed on the EU market, it will also require the CE mark. The conformity assessment for the UK CA mark must be carried out by a UK-based notified body. The conformity assessment for a CE mark post 1st of January 2021 must be carried out by an EU-based notified body. To date, there have been no material changes in respect of the required safety and compliance standards for a CE mark or a UK CA mark, but of course, future divergence is possible. Dealing now with the change in status. Brexit has had an impact on the status of the economic operators within a supply chain, which involves UKCA and CE marked products. This is important because the regulatory obligations placed upon manufacturers, importers, and distributors differ. For example, if a German company sent goods to a UK company for onward delivery to a customer, the UK company was deemed to be a distributor with relatively light regulatory obligations. Post-Brexit, they would be deemed to be an importer, which carries with it more significant regulatory obligations. The importer's name and contact details must also be displayed on the product or packaging. The responsibilities of the manufacturer remain unchanged. It's therefore very important for companies within the supply chain to understand where they sit in that supply chain, what their role is, and be aware of the regulatory obligations which go with it. And finally, the impact of Brexit on the Consumer Protection Act 1987. Prior to Brexit, Section 2.2 of the Consumer Protection Act 1987 made three categories of persons liable under the Act in the event of a defective product. The first is the producer of the product, the second is those holding themselves out as producers, and the third is those who imported the product into a member state. Under Section 2.3, a supplier could also potentially be liable, but could avoid liability by identifying one of the parties listed in Section 2.2 within a reasonable period of time following request by the claimant. Importers were therefore those who first brought a product into the EU. As of the 1st of January 2021, with Brexit, the third category has been amended to say any importer into the UK for sale, hire, leasing, or any form of distribution in the course of a business. This means that someone who may previously have been a distributor of the product, as per my previous example of goods being brought in from Germany, would now be deemed to be an importer and would be strictly liable for a defective product under the Consumer Protection Act. This is particularly relevant as these distributors would often have been deemed to be a supplier for the purposes of the Act, and so would not be automatically liable. That's no longer the case for those first importers into the UK. Thank you for joining me, and I hope this has given you a flavour of some of the post-Brexit issues for product liability law. The next in our series of talks will be Genomics and COVID-19 by Karishma Parowa of Kennedy's.